Imagine having the important responsibility of making decisions for a loved one, maybe an aging parent or a spouse. It is a role built on trust and good intentions, but sometimes, even with the best of hearts, complications can arise. These situations can become particularly sensitive when finances or healthcare are involved. A conflict of interest for a power of attorney, or POA, exists when the agent, the person given the authority, has a personal stake in a decision that is different from or potentially harmful to the principal, the person they are representing. Essentially, their personal interests could influence their decisions, even unintentionally, leading to actions that do not solely benefit the principal. The core reason conflicts emerge is human nature and the complex interplay of relationships and finances. One common scenario is when the agent is also an heir. For example, selling a principal's home for less than market value to a family member, even if well-intended, could be seen as a conflict because it reduces the inheritance for other heirs. Another arises when an agent is paid for their services as power of attorney, and they choose to hire themselves for additional tasks, like home repairs, at an inflated rate. A conflict also exists if the agent combines their personal funds with the principal's money, making it difficult to track transactions separately. To identify and avoid these issues, it is important to understand the concept of fiduciary duty. A power of attorney agent has a fiduciary duty to act solely in the best interests of the principal, managing their affairs with utmost loyalty, honesty, and good faith. This means keeping clear and separate records of all transactions. You should also consult with an independent third party, such as a financial advisor or an attorney, especially when making significant decisions that could involve family assets or large sums of money. Transparency is key, so sharing financial records with other trusted family members can also prevent misunderstandings. One insider detail to remember is that most standard power of attorney documents do not explicitly define every possible conflict. This is why having clear communication and an understanding of ethical boundaries is so crucial. Some power of attorney forms might include specific clauses that allow for certain self-dealing, like transferring assets to the agent, but these must be explicitly stated and fully understood by the principal when the document is signed. Ultimately, recognizing when personal interests might diverge from the principal's best interests is vital for any power of attorney agent. By prioritizing transparency, maintaining meticulous records, and seeking professional guidance, you ensure that decisions are made with integrity and always serve the well-being of the person you are honored to representing.